Morning. It's really a pleasure to see you all today at our DPO branch. My name is Mira Suleimenova. I'm the legal counsel at Gentis. For more than a decade, I was working as an international lawyer representing companies in the European Union, Central Asia, the US. Since 2018, I'm specializing in the data protection field. I'm passionate about privacy because this topic basically concerns all of us, and it is a very dynamic field, and that's what I love about it. Gentis is a Viennese startup, so that's me. Gentis is a Viennese startup established in 2020 in the midst of pandemic, and it has been founded by 5 founders, and now we are 45 people on the team. Our people are stationed in Austria, in Hungary, Portugal, Italy, Germany, and UK. And we have developed a GDPR compliant server-side tracking solution that allows you to collect data as a first party and increase the data quality for your marketing activities. Our team working on a privacy enhancing solution to help businesses improve data quality and navigate the data protection field, and the DPO branch is part of this process. The DPO branch is a regular event to encourage the ongoing exchange of experiences between the data protection professionals from a wide field, from a wide range of activities. And because the data protection field is a very fast-moving field, and with this event, I want to bring more clarity around the data protection topics that are not so straightforward. Some of you have attended already the DPO branch in July, and we talked about the day-to-day challenges of the DPOs in the online marketing field, and we have received a lot of positive feedback. That's why we are continuing with this format. And today we will talk about the impact of Google Analytics decisions in the European Union that data protection authorities have ruled in the recent months. And we want to talk specifically about strategies and tips on how to comply. But before jumping into the topic, let me say a few words about the agenda of this DPO branch. So if you have now, if you wish so, just grab a coffee, get comfortable, and I will just walk you through the agenda today. So as I said, focus of today's panel discussion is Google Analytics rulings in the EU, and we will talk about the aspects of it in a view of steps and strategies to comply with the decisions, as well as outlook into the future, how to maintain compliance despite of the volatility of this field. And in the end, we will have a question and answer session with our panelists. So whenever you feel like during today's session, just post your comments and questions in the chat box. And at the end of the session today, my colleagues Andreas and Tomislav will pass me the most burning, the most interesting questions, and we will have the panel guests answer these questions. So now we are coming to the panelists, and I'm really happy to present our panelists. Let us start with Thomas Adumov. He is a Chief Privacy Officer at Didomi, the French software as a service company building privacy compliant preference and consent management. Thomas has worked from both sides of this field. He consulted companies and he worked as an in-house DPO. Thomas is based in Paris, and therefore I'm very pleased and very looking forward to his perspective on the position of the French Data Protection Authority, CNIL. Thomas, please tell more about yourself and Didomi.
I mean, you've said it all. Hi, everyone. So I'm a qualified lawyer in France, and I lived for 7 years in the UK, where I worked both in private practice and then as an in-house lawyer. And now I'm the Chief Privacy Officer of Didomi. So Didomi is a consent management platform as well as a preference management platform. We haven't been impacted by the decisions of the CNIL directly, or our customers are not have not been impacted, but we followed the events as they were developing across Europe. So we're really happy to be here today.
Thank you, Thomas. Our next guest is Paolo Balboni. He is a founding partner of ICT Legal Consulting and a professor of privacy, cybersecurity, and IT contract law at the European Center on Privacy and Cybersecurity at the Faculty of Law at Maastricht University. Paolo is from Italy, and he has been advising his clients, among others, directly about the Garante decision on Google Analytics. Paolo, please say a few words about yourself and your activities.
Yes, thank you very much, Mira. First of all, for having me in this panel. It's a pleasure to share it with the other highly estimated panelists. Indeed, I'm a business lawyer with my firm, which has offices in multiple countries in Europe and also outside the European Union. We advise multinational companies. And the decisions of a number of supervisory authorities in Europe on Google Analytics has indeed impacted many, if not all, our clients. So there's been a lot of discussion going on in the past months. Yeah, I'll be happy to share some insight and experience. Also from the academic perspective, because I think these decisions put it in the context of also the whole issues of data transfer are very interesting also to develop into a debate more at the European and general level about data protection. Thank you very much.
Thank you, Paolo. Also on this panel is Gregor Koenig, who is a Group Data Protection Officer of Erste Group, the largest bank in Austria. Gregor previously worked in a management position at the Austrian Data Protection Authority, and he is also teaching at the University of Vienna. Gregor, I think your input is really valuable because you have experience on looking at cases through the lens of a data protection authority. Please tell us more about you.
So sorry, having problems with setting me not silent. Yeah, thanks a lot for having me. Actually, good morning to all of you from my side. I have been working for Erste for now approximately 8 years. We are not only a big bank in Austria, but one of the biggest banking groups in CE countries. So we have to look at this from a multi-country perspective, so to say. Yeah, I was previously engaged with the Data Protection Authority. I'm still, so to say, part of the member of the so-called Data Protection Council, which is a consultancy body for the Austrian government in data protection matters, not only in the field of data protection regulation in the banking area, but in all other legal areas as well. So I got a, so to say, look over the banking area, or far of the banking area. Yeah. And yes, of course, I also have a perspective and look at the developments around Schrems 2 and Google Analytics, both from a practical input on a big banking group on the one hand, but also from a perspective of analyzes this from a sole academic perspective as well, because that's actually normally the approach that Data Protection Authority is taking in that respect. So thanks for having me and looking forward to the discussion.
Thank you, Gregor. Last but not at all the least, we have Oliver Thompson, the General Counsel of Sever Stiftung. Sever is an international photo processing company, one of the largest in Germany. At Sever, Oliver is managing the legal side of IT topics, e-commerce, and data protection. And Oliver is also an enabler of Herbst Academy, one of the largest annual conferences in Germany on legal informatics and information law. Oliver, please tell us more.
Yeah, good morning, everybody. Hi from the upper north of Germany. So I think we're spread all over Europe here in the panel, which is actually, we're not one of the biggest in Germany. We actually are the by far the biggest in Germany and the biggest in Europe. And this company is sort of a dinosaur because we have been handling photos for the last 55 years, starting in the analog business, and we're processing at least 1.5 billion pictures in our group every year. And as you can imagine, from the very beginning, even in the 1950s, it was extremely important for our business model that we have the trust of our customers, that we do not spread around the information that we will find in the pictures. So we have a deep look into people's life, and therefore we really need to take care of the trust, and that's why data protection and data security is so important to this company. Thanks.
Thank you, Oliver. I think it's a perfect transition to our next slide. And actually, I want to start with a small game with you, dear audience and panel. We will now conduct a poll, and I really ask you, dear audience, to participate in it. So, you know, the question is, would you rather protect your privacy as a consumer and switch off personalized tracking, or improve your sales as a business and switch on personalized tracking? Please run the poll, and I will just give you a little bit of background to this question. So all of us here, I believe, are data protection professionals, and we, in our day jobs, really work hard on compliance and trying to figure out the ways to comply with existing regulation, navigate this extremely challenging field of data protection. But then when we leave our jobs, we are becoming normal citizens, and we come home I do, for example, my grocery shopping online, or I'm looking for a perfect gift for a friend, you know, and I am overwhelmed sometimes with the pop-ups and everything that is jumping at me from the screens. And the question is, what are you leaning towards more, privacy or personalization? And unfortunately, you cannot choose both. This is a binary poll, and I just want to have initial reactions from you. So, do we have any statistics at the moment? So I think, yeah. Let us have a look at this. Okay, protect your privacy as a consumer and switch off personal tracking, I guess, or personalization. And 22% are for increasing the sales of the business and switching on personalization. This is an interesting result, and I think maybe let us elaborate on this with the guests of the panel. Oliver, what do you think about the results? What is your take on that?
Mike again, sorry for that. Well, it doesn't really surprise me on depending on the people who you ask. And since we're all interested in data protection, we kind of obviously go ahead and say, yeah, we need the protection. But what I think behind those questions is that we have to figure out whether it's good to have not personalized marketing towards the customer. For example, if you send me something for dresses, I rarely wear dresses, and therefore I'm annoyed by this newsletter or whatever. So is the pain for me to be bothered by newsletters that I really don't care about and give away some of my personal data for that, or is the pain to give some of my personal data to the companies and then get only information that I really care about? And I think that's a hard question. It's hard to answer. It's as a company, you always need to improve your sales, because that's where your money comes from. And those marketing people work hard to do so, but when they go home, as you pointed out, Mira, their position might change. They would really love to keep their personal data to themselves. So I don't think it's an easy job. It's not easy for the legislation, because we need to have some regulation on that for obvious reasons. But in our times, I think it's hard to really find the right balance of the interests of everybody.
Thank you, Oliver. Gregor, what do you think?
I think the question is a little bit unfair, I must confess. Yeah, so the binary option, I know we have talked about it, we've discussed this, but if you look at it, it's the binary options, of course, which actually drives us in the one or other direction. And as pointed out by Oliver already, it's the audience which obviously is more privacy, so to say, friendly than if you look at the, I would say, another population. If you would provide, for example, more different options, it might look different depending on some situation where you would really like to have something personalized for you, something which is really targeting specifically you, and then the other way you're fine with some generic offers, if any. So that might be having some influence. But one thing is, I think, really important, and if we would have asked it otherwise, I think that would not only here but in another population as well work, is the thing that you have the ability to switch on or off. So you are the one who in the driving seat. So that's I think one of the important things, rather than you, so to say, are forced to accept targeted marketing, for example, or marketing measures, or the process of your personal data. But so that, I think, would also be an interesting question, interesting output.
Yeah, it's, I mean, sometimes this dilemma is put on this polar scale, right? Either yes or no, but I agree with you, Gregor, totally, that there should be more options, or at least more creativity to this, to solutions. Thomas, what is your input? What do you think?
I mean, similarly, I think the question is a bit unfair, of course, but I think it really depends on what we put behind what we mean by personalized tracking. There's many ways to track people online. They're not all bad when done properly, I would say. And also, I think we have to acknowledge the fact that tracking to a certain extent is what makes internet possible. Getting access to free content of really good quality and services as well, without having to pay for it, wouldn't be possible in an economy where advertising online is not, or like, is not allowed. I think there are currently discussions at the European level to eventually get rid of digital advertising. I'm not a big fan of seeing ads online, and I don't work in the advertising industry, but I just realized that this is necessary for to get the internet as we know it. So that would be my 2 cents.
Thank you, Thomas. Paolo, what do you think?
Well, I think personalized tracking, let me spice up the debate a little bit, because I've heard a lot of politically correct answers, and all absolutely true and clear. But at the end of the day, I think personalized tracking nowadays is necessary, and for multiple reasons. For sure, there is a portion of business reason around it. It's also how the internet works. I think I find it more interesting to try to discuss on for what purpose and the behavior of the organization that are tracking. I think that is the main issue, not the fact that we are tracked as users. And I think when I look at the legal basis and the approach of the supervisory authorities, that is very much looking at consent. I'm very skeptical. I have a lot of doubts because it's a free pass for organization to process personal data and track without a true understanding of the general public, and it does not say anything about how they will then process personal data in the background, because if it is only for business reason and to provide you personalized advertising, I don't have much problem about that. But we all know that there is much more that happens in the background. And therefore, I think, and I introduce another dimension that, for example, at Maastricht University, we have created under my directorship the first data protection as a corporate social responsibility framework, working together with supervisory authorities in Europe and outside the European Union. And I think that we need to introduce an additional dimension in order to guarantee a true protection of the individuals that goes beyond what is legally required by the law. And I think it's very important to look into that, because as a business lawyer, I can definitely advise my clients to do tracking of users in a lawful way. But once again, it doesn't say anything or prevent data processing activities happening in the background that can even lead to discrimination and procure severe damages to the individuals. And that's what I'm very concerned about.
Yeah, thank you, Paolo. I think this is a very important point you made about this balancing of interests. And since our focus today is Google Analytics decisions, and I think it really comes to that balancing of interests of both consumers and really understanding what business needs. Because Google Analytics is just one example in the grand scheme of things that make companies respect the data. And everyone expected some sort of a decision, but from what I hear from many of our customers, that it was unexpectedly harsh. So, in January this year, we were receiving a lot of, feedback asking us, so can we use Google Analytics at all now? Why not and why yes? Yeah. So let us talk about the steps and strategies your businesses or your clients have implemented to comply. What steps did you have to take as a company, and what strategies to put in place? Gregor?
Yeah, I will start. I mean, actually, we were not really surprised about the decision, I must confess. Yeah, we have been monitoring and tracking the situation around third state transfer since the Schrems II ruling of the European Court of Justice. And what was a very important thing back then, but also with the Google Analytics decision and the other decision, was communication. Communication within our group, of course. Yeah. So we don't have, in terms of tracking, for example, a group solution valid for each and every website in our group. So there was a need also to communicate the consequences for the different tracking solutions used on the different websites in the different countries. But also the communication to our board members, and those who are familiar with internal processes and communication processes know that it's probably sometimes not very easy to on the one hand really create understanding for the board and to explain why that decision has been taken in that way. On the other hand, we needed to come forward. I must confess, we don't use Google Analytics on our websites in Austria. So in the part where I'm operationally responsible, I can be happy and say, well, we were compliant from that perspective back then, but we have the one or other discussion. We had the one or other discussion in other countries, and actually we were really discussing the different options which to be taken. And actually, I could now take the hat back from my previous times from the Data Protection Authority when it was a very very much again binary approach. Actually, one thing is compliant or one thing is not compliant to data protection law. In a company, of course, sometimes the discussions run a little bit different, and it's also about the risk management in connection with the one or other decision. So we were discussing whether, well, we should stop all the activities of tracking around, so that would be the safest way, or we ask for the legally probably not so clear way to ask for a consent. Since one can discuss whether this is then still connected with a free will when you ask for the consent in connection with the use of the website and then the subsequent transfer of personal data outside of Europe. We were also asking whether should we still or just wait for the, so to say, political decision or solution in the case. I'm talking about the transatlantic data privacy framework, which has been announced in March. Also driven mainly by the different decisions of the authorities, or that we discuss, so to say, technical measures as an intermediate. So the thing which is requested from the European Court of Justice ruling and also from the EDPB recommendations, that you simply avoid to send personal data to the US with some middleware. And well, actually, you know best, we are going this way to have here such a possibility to really avoid the problem where it is not necessary, because we still would have the tracking capabilities which our business needs. So that was the one thing. The other thing, of course, we were also, and that is the possibility, of course, not everyone has. We are quite aware of that. That we were closely staying in contact with Google as well, because actually, well, they are affected mostly by these decisions, as it is, so to say, applicable to all their customers, and looking and also looking the development on their side, so what they are doing with this decision. That's also an approach we took with the other partners we have in connection with the Schrems 2 implications. So that's a glance of what we did, so to say, with that rulings.
Yeah, thank you for sharing. I think this is a really interesting perspective, because since you have so many moving parts in your organization, there are, it's a very international organization, and there is a lot of structure, as well as the specifics of the sector required you to be extra, pay extra attention to the risks that your organization may potentially face. I think this is very important what you are saying, that it's not an easy yes or no answer. You just have to find like a more complex approach to solving the issues. Thank you, Gregor. I would like give a word to Thomas, because I think he might have like a different perspective, since Didomi is dealing with the consent and preference management. Maybe you can have your insights, Thomas.
So first, I would say that as a company, we were using Google Analytics, and we, to avoid any confusion, like we decided to stop relying on Google Analytics for the time being. We also implemented a solution that's exempted from consent. So we followed the guidelines from the French Data Protection Authority, the CNIL, to implement an analytics tool that's not intrusive enough to not be exempted. So we benefited from an exemption. So we do not ask for consent for analytics on our website. Having said that, we received many questions from our customers when we saw the first few decisions coming. We were also not surprised. We knew that all the Schrems complaints were being taken care of by data protection authorities. And also we had seen a decision in December, I think it was in Germany, regarding CookieBot and the fact that they were using an American CDN like the rest of us, but there was already a decision that wasn't really based on the risk, the risk approach, the risk-based approach. But so what we ended up saying to our customers first was, you know, like we really tried to be cautious there. We couldn't just say like stop using Google Analytics. For many companies, it's just not possible, and it doesn't happen in one day. So we tried to implement solutions to make it like more or like to make it clearer for users that there was potentially a transfer to the US. We also explored the possibility of obtaining explicit consent for the transfer to the US. But we very soon realized that it wasn't really an option. That's not something you can actually deliver. And the French Data Protection Authority actually in a Q&A regarding the Google Analytics decisions said that the explicit consent that you get as an opportunity in GDPR is not something that you can rely on when it comes to an analytics tool or any kind of tracking that's operating on a website. So what we ended up doing a month after the first few decisions was to either recommend a few alternatives, so other solutions that exist in the market, and even though we were no experts, we sort of became experts when it comes to analytics tool. But the second thing that we did was, in fact, to partner with Gentis to provide a proxy solution, because that's what again the French Data Protection Authority in this Q&A that I was referring to, they said that the proxy solution, so and in a nutshell, pseudonymizing the data before it hits Google's servers, was potentially a solution. And so that's what we're recommending at the moment. That's what we're pushing for, and we are actually happy to use Gentis for that.
Thomas, thank you so much. I really appreciate you, like your answer, because I think I also believe in the solution of Gentis as a proxy, and I really do appreciate that you mention it. We have a lot of questions, very interesting questions coming in. That's why I would really like to, you know, skip forward and maybe Thomas and Thomas, thank you, and Oliver. Could you please share your experiences in a nutshell, so we can jump into the next session, into the next part of this discussion after, you know, after we hear also Paolo's perspective. Just very shortly, maybe a summary of the of what you as a group, Sewe Stiftung legal counsel, advised to undertake in terms of Google Analytics compliance decisions.
Yeah, I think almost everything has been said before, so I will not reply on that one. But what came up as a European company with more than 22 different European countries that I have to handle is that we really had to improve our communication in the group on what we are doing with the tracking. We host over 6,500 websites, and for our business customers, you can imagine that the French maybe want to have a different analytics tool than the Swedish, than the Polish, than the Italians, and we really had to you know, tie all this together and find a way of dealing with each and every different legislation in Europe. Sounds easy, is not. You know, the CNIL is different than the German data protection officers, and that was kind of hard to do. And actually, we're still working on it, trying to find out each bits and bytes what is legal and what is not. So we're still on the path. I think we do not perfect, but kind of fine. But it's a harsh thing to do.
Thank you, Oliver. Paolo, very shortly, what did you advise your customers or your clients to do in connection with Garante case specifically?
Well, the Garante case, I think is interesting also in terms of timing, because the Garante gave 90 days, which expired today, actually. So it's very interesting to see what is going to happen by tomorrow. For Caffeina, this company, to correct the data processing activities with respect to Google Analytics. I think I just would like to add two insights on the analysis that was very well reconstructed by my colleagues. First, of course, moving away from Google Analytics for many organizations is super difficult, because they have already based large investments and business models on the information that they capture from Google Analytics. So it's a slow process for sure. Looking for alternatives, it is what most of our clients are doing in this moment, and also looking at GA4 and to try to understand whether there is a way to leverage it in compliance with what especially the French supervisory authority has said, because it has been the most vocal in that respect. I just would like to point out one possible misunderstanding, because there are a lot of organizations that look at the list of the CNIL for the audience tools, and they think that by deploying one of them, everything is going to be fine. But if you look how it was presented by the CNIL, it's just a list of potentially good tools that needs to be set and analyzed in order to carry out audience activities and measurement in compliance with the guidelines of the CNIL, which is completely different than saying you can replace Google Analytics by taking off the shelf one of them and implementing it. You still need to make the regulations, the actual tweak to that tool to set in a proper way. And it does not cover at all data transfer. Which is another point. And before, it was also mentioned that for the transferring of personal data, the consent should not be relied on. And definitely it is absolutely right. Even if you look at the GDPR Article 49, this is a derogation and cannot be used for systematic data transfer. So that cannot be a solution. So I think the situation is way more complex than it has been perceived, I think, by the large public and the key function within the organization, that are either saying, okay, we move to GA4, wait a minute, you still need to have a thorough analysis of GA4 and see whether, this will deliver what the supervisory authorities have recommended, or turn to the CNIL list, because this is, the quick solution in case it will still serve the business. But it is also not like this, because still you need to set and to understand how you may cope with possible data transfer. So these are, I think, the 2 points of attention that I wanted to add to the discussion.
Thank you, Paola. Really insightful. I think it's very useful what you just said. We are now very fast running out of time, and actually, based on the timing, at this time, I was going to introduce the Q&A. That's why I think we have a few very interesting questions and very relevant that came in. Let us jump to the, to the questions and answers, because I think this is the most important part of this DPO branch to exchange with the audience. One of the questions that I also am curious about is, so the Google Analytics decisions and Google Analytics, can we take it as a synonym to all other US tools? What do you think, Paolo?
Well, we need to look at the decision from the functional point of view, not looking at the name of the parties. I think it has been consistently repeated by multiple supervisory authority, namely first the Austrian one, then the CNIL, and then the Italian one, that if you use analytic tools that transfer personal data outside the European Economic Area to countries that do not have an adequacy decision, so it's not just about US, it's about any country that does not have an adequacy decision, then you need to comply with the GDPR, meaning that you need to find a correct and lawful transfer mechanism, which cannot be the consent, because that is typically a repeated transfer and not an occasional transfer, which makes it very difficult, because it means that you need to do a TIA, a transfer impact assessment. And I think that all my colleagues would agree that a TIA is not an easy process to do. And if you think about doing it for multinational companies, and here I'm getting even out of the discussion of the audience and analytics tools, but just doing transfer impact assessment on all suppliers, including the provider of analytic tools for a multinational, is a nightmare. Because if you do it properly, you need to engage locally qualified lawyers in the country where the data will go. They need to connect with the European lawyers and make sense of what it is a possible conflicting legislation with the rights and freedoms as we know in the European Union. And at the end of the day, and here I also want to draw the attention of the audience on another misconception: you cannot put in place a risk-based approach on data transfer. You can put in place a risk-based approach on data transfer on all other provisions of the GDPR, but not on Chapter 5, which I think is questionable, but it is what is written there. And in the guidelines of the DPB on supplementary measures for the transfer of personal data, it is specifically indicated that you cannot base your decision on how likely is that law enforcement in the country where the data will flow may request access to the data. And unfortunately, I've seen a lot of TIA scheme and model that, on the opposite, they concluded the analysis based on the likelihood of the access of law enforcement authority to the data in that specific country. And I think we need to be extremely careful about that. So at the end of the day, it's not so important that it is written Google. We need to understand what is the core, what the European privacy ecosystem is telling us, which I think is very, very dangerous in terms of, I think, systematically exposing the economical players to a risk of sanctions. Because I think as the legal framework around transfer is developing, is almost unbearable for the economic players, especially multinationals, which means that you always run the risk to be sanctioned, which means that you cannot do investment and planning and budgeting in order to develop your business, and at the end of the day, make our economy weaker and also our society weaker. So at the end of the day, I would say I don't have anything against the decision from the theoretical point of view, but from the practical point of view, there is a lot of distance in terms of what is requested and what is possible to do. And I think it's duty of the authority to reconcile that gap, because we want both to foster business and protect individuals. In this moment, we have too much unclearness in that respect.
Thank you, Paolo. I would like to continue on this topic because I think it's extremely important to understand that it's really not only about Google Analytics, but it's a systematic thing where you have to really find a strategy how to deal with it. And Gregor, I think you would be really in a good position to answer how systematic, like what is the system or strategy behind for a large corporation like Bank Austria, Erste Bank.
That's one of the competitors.
To approach this.
Yeah, I mean, actually, I fully agree, so to say, on what Paolo has said. If we now go a little bit away from Google Analytics as such, as I said, the topic was already around when Schrems 2 was issued, so to say. So we have had the topics since then, and our strategy back then, if I go back now 2 years, in the very first half year since after the judgment, it was more around discussions with the vendors, understanding what they do with that. So how can we prevent the transfer of data? And in the meanwhile, we have then, so to say, established a transfer impact assessment. As Paolo also mentioned, there is no risk-based approach, or there is no risk-based content in that. But we need to do that. We need to do it specifically, first of all, with the parts of our group of companies which are outside of European Union. We have, for example, some bigger establishments in Serbia, and we needed to do that then transfer impact assessment, and really, as pointed out, with the help of local lawyers, with the help of the local authorities, if any, if it's available. So that is necessary, and it's key. So it's not nothing you can do, so to say, from Vienna and look into the foreign laws. So that's a key message here. And if it's about the vendors and the partners we have, of course, then there is a need, for very much help from their side as well. So they should know where they operate, where the sub-processors operate, and insofar then we request this transfer impact assessments from their side as well. Of course, not all the assessments are positive. That's sure, specifically for the US. But as I pointed out, of course, then there is the risk-based approach from the coming from the GDPR, but there is also internal risk processes to look from the perspective of a company. So, and then of course somehow the likelihood and the impact as far as one event is occurring is of course of importance. That's the part of risk management which is part of the business, not only in the banking business but also in the banking business.
Thank you, Gregor. My next question goes to Oliver, because I think, I mean, there is, I believe there is this need to understand how far reaching the consequences of Google Analytics is, right? And from what we have discussed today, it's clear that the Google Analytics decisions are just a very tip of the iceberg, and basically it's going to be a systematic shift in how organizations approach data compliance. And one of the things that is now, also discussed and kind of anticipated is the transatlantic data transfer framework. And on one hand, on the other hand is whether or not these kind of decisions can also be applied to, for example, to all other tools that Google is offering to the market. And the third part of it is, okay, there are US tools, and we understand why it is, why the risk-based approach may not be working, and why is the background of the decision, why the decision on Google Analytics is so harsh. But there are also other third countries, like Japan, for example. How is it these decisions on Google Analytics may affect the strategy in relation to all other third countries? I know it's a very loaded question, Oliver, but I'm sure you will find a very, very good answer to that.
Thank you. Let's hope. Let me start at the end. This decision is clearly not only on the United States, and we used to have people working for us in Tunisia, and it was for us, as not being a billion-dollar company, it's kind of questionable whether or not we should use those services again. So we simply cut them off, which is not so nice for the people working for us in Tunisia. But going through all the processes that Paolo and Gregor just explained, for us, for this little subsidiary in Tunisia, was just not good. It was too expensive, to say the truth, or to tell the truth. And that is something that Paolo really, said very, very well. We are not in balance anymore with, on the one hand, data protection, and on the other hand, the business that needs to, earn money to pay people to do something. So it's getting more and more complicated at the minute and whilst we speak. And for example, if as a company you really have to figure out where you put your money in and where you do invest. And now we come up with a third agreement with the United States on how data transfer should work. And then, you know, we switch our systems to that, because obviously we have to transfer data to the United States in our times. Just, you know, using not only Google, but also Microsoft and whatever, Salesforce, you name it, you got it. And then we shift everything. We invest a lot of money in doing so. And who knows whether there will be a Schrems 3, you know, and this uncertainty really hinders us to do good business decisions. It's harsh. It's not for me. I don't want to be, you know, the bad guy, but if we do not find the balances, we will see more and more European companies losing touch to the rest of the world. And that really will not help us with our economical status that is endangered right now anyhow. So we have to you know, not giving free access to every personal data that there is, but we have to have some certainty in how to plan our invests and how to make money. Sad story.
Oh, what
your questions?
I think what I take from your answer is that, yeah, it's not so easy to navigate, but you know, as long as there is a clear communication, as long as there are, you know, clear priorities and also a budget for taking the decisions in terms of how to really, in an effective way, to work with the data that you need as a business, then you know, and it takes a lot of input from all other parts of the company, right? Not only like in the headquarters, but also externally. So you have to really think of the moving parts, like, for example, in terms of transatlantic data framework, which is, no one knows when to expect it, but everyone is saying that it's going to be maybe sometime early next year. You know, you have to really look forward and think, okay, what would that bring for me as a company? Or if you look at the subsidiary structure, you have to think, okay, what subsidiaries are outside of the European Union and what do I have to do with them? Then you have to look at the vendors list and decide, okay, half of them are from the US, but there are also some from, I don't know, countries like Japan or Brazil, and how do I approach, what are the steps to do that? So do I understand your approach correctly, Oliver?
Yes. Thanks for summing it up.
Yeah, thank you, Oliver. And I think we will conclude now the discussion round, but one question I have for Thomas, and if it's possible to put it really shortly, because we are now running really fast out of our time today, you know, about the proxy recommendations by CNIL. You said that you have implemented the proxy solution, and there is a question of which one of the 18 proxy like audience measurement tools you have implemented, if any. Maybe you can give us some tips, or like what is your take on this proxy list of or not proxy, I'm sorry, the tools on audience measurement recommended by CNIL. What is your take on that? What is your view on that? Very shortly, please.
So yeah, as a company, we actually, can I start with a quick comment, and I'll be really quick. On the risk-based approach, I just wanted to say that I've noticed a statement from a data protection authority in Germany that's saying that the risk can actually be taken into account. I'll post the link. I don't speak German, but I looked at an English translation, and I think it's really important to notice that not all data protection authorities seem to agree on that. So sorry, preliminary comment. Now to your question, so we haven't implemented a proxy ourselves. We do not need that because we use Matomo, and we've set it up to Paolo's point, following the guidelines of the CNIL, so that we don't have to obtain consent, so it's exempted. The reality is, when you do that, you get access to limited functionalities. It's not the same as a full, Google Analytics solution, but for the time being, it's enough for us, and we don't have like a huge corporate website anyway. As to the solutions that exist, honestly, we've looked at them. I'm not the expert at the company. I don't take care of all the digital work. I looked at the way we implemented Matomo, and it was very much satisfying from a data protection standpoint. So I wouldn't go into that. But if I can just add a comment on the general atmosphere on Google Analytics, I would say that, of course, it goes way beyond Google Analytics itself. One thing that worries me is when data protection authorities are going to look at what's currently happening in the digital advertising industry, with so many vendors and players that are actually getting access to information when users show up on a website, and most of them are actually American companies. When that happens, when data protection authorities are going to start looking into that, I don't know exactly what's going to happen, but I'm worried that it's getting to Oliver's point, it's getting so complex now that to a certain extent, that's going to end up discouraging companies to comply. Like, why would I even try when it's so complex and I will always have a liability? I will never be sure that the data protection authority will find me or not, because I'm never going to be able to say that I'm 100% compliant. And I think it's worrying, because a lot of companies have done like a lot of efforts to comply with GDPR back in 2017-18 when it came into force, but now it feels like companies are getting discouraged by the complexity, the amount of money that it costs.
And also, I totally agree with you, Thomas. I share the same feeling, and what really is missing is the other part of on how the authorities should work. They should work as a help, and right now they're only on the track of blame and shame. So if you pick up the contact to any German authority, you really have to figure out which one to take, because there's one or two or three that will just fine you for the question, because they tell you that you're non-compliant, even in beforehand. And I think that is really where we have to aim for. We have to have the situation on where you can ask the authority in beforehand, and if you're not sure, and then they will give you advice on how you do it, but also on an advice that is practicable and workable. And right now it's all theory driven, fine, but the fear of fines is getting less and less, because the other way is extremely expensive too. Totally agree.
Thomas, Oliver, thank you for your input. I unfortunately have to wrap it up, because but I think it's super interesting discussion, and maybe for the next round we could talk about what do we expect from how the future should evolve, and what would be like the sensible way for us as organizations and as us as consumers. We can explore more about this balancing of interests, because there is a lot going on within an organization when you have to make a decision, and this is not an easy decision, never an easy decision on how to implement the strategy. So I want to everyone who has attended the webinar, I really appreciate all of the inputs from the panel, but even more, I appreciate the active participation of the audience. And as a gift of appreciation, I just want you to know that we are holding a Heroes of Data Privacy event on 26th, 27th of January. And again, our next branch is on 11th of November. If you have ideas or if you have feedback about today, or if you want to, nominate a speaker for the DPO branch for the next one, please feel free to contact me at mira@gentis.com. Thanks again for being here, and thanks again, dear guests of the panel. I really appreciate your taking the time, and we will see each other next time. Thank you very much.
Thank you. Bye-bye.
Thank you. Bye-bye.
Bye.
Thank you. Bye-bye.
Bye.